Officer Dave, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. This appears to be one. Good morning.
Good morning.
This is file 22.
See, Judge, I don't think I can hear you. Let me try something here.
Can you hear me now?
I can hear you.
Yeah, I can hear me too.
I still, oh, you know, it's probably the microphone.
It's Mr. Saloon's problem. Can you hear me now?
I still can't hear anyone. Judge?
Yes.
I don't think I can hear. Let me try to see if I can. Oh, that might be why.
Can you hear now?
I can.
What have you failed to do?
I'm sorry. Oh, the audio? Yeah, I apologize for that. I thought it was good to go there.
That's why you don't test rocket ships. Let's go to work.
Okay.
This is 22-192-478. Discover Bank versus Tamiko Polk. Date and time for what appears to be our second pretrial. I note for the record that a motion for summary disposition has been filed on behalf of plaintiff. Your respective appearances.
Good morning, Your Honor. For the record, William Saloon, P41487, appearing on behalf of plaintiff, Discover Bank.
And your name, ma'am?
Tamiko Polk.
Okay. We were last together on this file on February the 7th. At that time, the court opened your written discovery. I have a motion for summary disposition that was filed on behalf of the plaintiff. Anybody going to do any written discovery here or not?
From plaintiff's perspective, Your Honor, we don't request any, we don't require it.
Okay.
I don't know about defendant.
What about you, Ms. Polk? Are you going to do any written discovery?
I'm not understanding what written discovery is.
Discovery is your opportunity to learn about the claims and defenses of the other side. It includes such things as written interrogatories, questions to be answered under oath, requests for admissions, and requests for production of documents and things. Those are things that are provided for in admission courtrooms, and you've elected to represent yourself, as is your right. And then those are the written discovery tools that are available for you. If you're going to use them, let me know. If not, let me know, and I'll just move forward to the motion for summary disposition.
I don't have any written dispositions.
You don't want any doing written discovery? Okay. Then what I'll do is I'll calendar in the motion for summary disposition.
Thank you, Your Honor.
And what exactly does that entail?
Have you received a copy of the motion for summary disposition filed on behalf of the plaintiff?
Yes.
Then I'll set it for hearing. If you wish to file a response, you can file and serve your response, and we'll hear the motion on the next day that I set up for hearing. We'll set it up for hearing April 4, 10 o'clock. Does that work for everybody?
It does, Your Honor.
Okay. Does that work for you, ma'am?
Yes.
Okay. April 4th at 10 o'clock. Written discovery is now closed.
Thank you, Your Honor.
Out to you both today a notice of the hearing on that motion, and thank you both for coming in.
Thank you, Your Honor. Have a good day.
Let's be safe out here.
Thank you.
Thank you.
Thank you. Mr. Smith, good morning.
Good morning, Your Honor.
What file do you have today?
LAFCU v. Crump. Carrie.
Okay. I think we'll be ready to go shortly.
Thank you, sir.
As soon as she connects, we can get started. I got picture, but I don't have audio as of yet. Here we go. Good morning.
Good morning. I'm doing it for my mom, Jimmy. 1 second. Good morning.
Good morning. We are on the record calling file number 23140-351, LAFCU versus Carrie Crump. Date and time for what appears to be our first pretrial, your respective appearances.
For plaintiff LAFCU, Tim Smith, P48259. Good morning, Your Honor.
Good morning. And what is your name, ma'am?
Carrie Elizabeth Crump.
Is it your intention to be your own lawyer here?
I don't have an attorney.
Okay, I'm saying you can hire a lawyer or you can be your own lawyer. You have an absolute constitutional right to represent yourself. What you do not have is the right to your own set of rules, civil procedure, your own rules of evidence, your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that are binding on Mr. Smith are binding on you. Do you understand that?
Yes.
Okay. So where are we on this file, people?
Well, Your Honor, there was my client financed the purchase of a Chevy Malibu. There was a default on the contract. Repossession occurred. Suit was filed on what is effectively a repossession deficiency balance owed on the contract. After service, I think the court file reflects an answer filed by the defendant. I believe every box was checked. I disagree with each and every aspect of the complaint. So that's my understanding of where we are, Your Honor.
Okay. And what's your position here, Ms. Crump?
Did you? I don't understand either. Yep, I did. I did say I disagree on.
Okay. All right, this is what I'm going to do. I'm going to open your written discovery. Discovery, Ms. Crump, is a way by which you can learn about the claims and defenses of the other side. It includes such things as questions to be answered under oath. Those are called interrogatories. Requests for production of documents and things, and requests for admissions. If you elect to participate in written discovery, you must serve whatever you're going to serve on the other side. Anything going forward here, if you elect to represent yourself, anything you file with the other side must be filed with the court. Anything you file with the court must be filed with the other side. You also have the right to hire an attorney, have that attorney file an appearance. The appearance is a document by which the attorney says he or she will represent you. So I'm going to open your written discovery and I'm going to give you a return date. Your written return date with me will be April 4, 10 o'clock. Does that date and time work for everybody?
Your Honor, it works for me. You bet.
That work for you, Ms. Crump?
Yes.
Okay, so here's what I'm going to do. I'm going to send out an order today for April 4th at 10 o'clock. We'll be on Zoom like today. I'm going to open your written discovery. Now, what I'm going to do now is I'm going to put you two into a chat room so you can talk about your case outside of my hearing. If you settle the case, come back to me. If not, I'll see you April 4th at 10 a.m. Thank you both for coming in.
Thank you, Your Honor.
Can I ask you a question?
Ma'am?
Okay, well, I mean, can I get me appointed attorney?
Ma'am, we only appoint attorneys in criminal cases.
Oh,
This is a civil
okay.
case. Yes, ma'am.
All right.
You might want to try, let's see, Lakeshore Legal Aid does civil defense for free. Both of the law schools, Wayne State and U of D Mercy, have clinics where they provide little litigation. State Bar of Michigan, you can go on the website. They have people who provide free representation. And you might find some more information on the Supreme Court of Michigan website as well. So let me get you guys to a chat room. And I'll talk to you again April 4 at 10 o'clock.
Thank you.
Okay?
Thank you, sir.
See if I can make the technology work today. Ms. Crump.
I'll see you to another room with somebody. Let me see.
Thanks again, Your Honor.
All right, thanks for coming in. that. What do we got? Carter. Let's see, I got Ruser. So this is who I guess I need to find. Hello,
Yes,
what is your name?
Tammy Walton.
All right, hold on for just a second. We are on the record calling file number 21. I'm sorry, file 23-140-007, Credit Corporation Solution versus Tammy Walton. Date and time for what appears to be our first pretrial, your respective appearances.
Judge, may it please the court, my name is Attorney Richard Rusin. I'm the attorney of record for the plaintiff. My bar number is 35222, and I'm also the attorney of record for the plaintiff in pretrial today.
And what is your name, ma'am?
Tammy Walton.
Ms. Walton, is it your intention to represent yourself in this matter?
Obviously, I guess so, sir, because I've been trying to seek legal counsel through the court, but they told me that with this matter, I wouldn't get a counselor.
Well, you don't get an appointed lawyer, but you can hire a lawyer for yourself, or you can check
Yes.
in one of the places that might provide legal aid, say Lakeshore Legal Aid, both the law schools in town, Wayne State, as well as the UD Mercy, have clinics that provide free legal services as well. The Detroit Bar Association has lawyers who provide free legal services, and the State Bar of Michigan. You can check those websites as well. Okay, so.
Yes, yes, sir. I definitely will, but because I've never been to court for being sued or any other matter, I didn't have knowledge of those places. Plus, the hours that I work at my job didn't permit me to be on the phone all day. But I'm here. I can definitely explain my situation, why I came to be to this point. But I don't have legal counsel at this moment.
All right, we will proceed then in the absence of counsel. If you get a lawyer, have the lawyer file the appearance. The appearance is a document by which the lawyer says he or she will represent you. So what I'm going to ask you, Mr. Rusin, what's your case about here?
Judge, I have a case that's on your docket as an assigned debt. It's a first-time assignment. I was looking at the 60 credit card statements. It was a credit card under the brand name of Surge. They all went to Miss Walton at her McKay Street address. The amount of the suit is $1,131.86, which was the date of the last, the amount of the last statement prior to charge off, and then placed in litigation with your court. So I would ask for discovery so I can send these statements to defendant. She can review them. Review the veracity of them. If she wants to contact my office to talk about settlement, or she's invited to do so anytime between Monday and Friday, 8:30 a.m. to 7 p.m. On that I rest.
So what I'm going to do is I'm going to open your written discovery. I'm going to give you both a return date. It'll be on Zoom again like today. That return date will be April 4, 10 o'clock. Does that work for everybody?
Yes, Judge.
Does that work for you, ma'am?
Well, I will have to see if I can get off work because I work at the city county building. And I'm not always able to, depending on if I have any vacation days. But, I'll just tell them it's court, but I just don't know exactly yet till at least ask my superiors if I'm good to have that day off.
You don't need the day off. You don't have to come in person. We're doing this on Zoom, so you don't have to take a day off from work.
Okay.
Calling in on your cell phone. You can do that. Okay, April 4th, 10 o'clock. We'll send you out an order. Anything else we can do today?
At this time, play press, Judge.
Anything for you, ma'am?
So this is what I wanted to know. So today, what was the purpose of today? Just setting a day. So when I come back to court, what will happen? I mean, we have another Zoom meeting. What will happen on that day to get resolved with this matter? Because I had 2 credit cards through them. I'm going to have to go to court April 18th for that. So I thought today this matter was going to get handled. So I'm just trying to see when I will be able to get this matter resolved.
Well, ma'am, I can give you and Mr. Rusin a chance to talk about, I'll put you in the chat room and you can talk about resolving your case.
Okay.
All right, I'll do that after I let you go. So April 4th at 10 o'clock, your written discovery is now open. Now let me get you into a chat room so you can talk about resolving your case.
All right, thank you, Judge.
Mr. Corpus,
Good morning, Your Honor.
what brings you here today?
It's a free trial, Woodbridge Estates versus Janai Lindsay.
Okay. I have one person who I don't know who they are. So let's see if this is she. All right, put you back in the waiting room and I'll figure out who she is.
Okay, thank you, Judge.
Samsung here. Hello,
Hello,
what is your name?
my name is Janae Lindsay.
Okay, let's get Mr. Corpus in here. Let's get started. She was here a moment ago. Don't go away.
I'm not going anywhere.
All right, we're back on the record, calling 22-198-388. Woodbridge Estates versus Janae Lindsay. Date and time for pretrial. Your appearances.
Good morning, Your Honor. Matthew Kuiper is on behalf of the plaintiff.
Bar number.
E71348.
And what is your name, ma'am?
My name is Janae Lindsay.
Ms. Lindsay, is it your intention to represent yourself in this matter?
Yes, I am.
You have an absolute constitutional right to do that. What you do not have is the right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind Mr. Kuiper are binding on you. Do you understand that?
When you say I can't use my own evidence, I'm just confused why I'm being
I didn't say
sued.
that, ma'am. I said you can't, don't get your own set of rules.
Okay, yes, I understand.
Listen to what I say. Don't put words in my mouth.
Okay.
Mr. Kuiper, what is your claim about?
Your Honor, this is a claim for post-tenancy damages, mainly past due rent from, it looks like July to November 2021 in the amount of $7,104.95 plus cost.
Okay, this is what I'm going to do. I'm going to open your written discovery and I'm going to give you guys a return date. Your return date with me, it'll be Zoom like today, April 4th at 10 o'clock. Does that date and time work for everybody?
Yes.
Yes, Your Honor.
Okay. Anything else we can do today?
Yes, I have a question, Your Honor.
Yes, ma'am.
This was dismissed. That's why I'm trying to figure out why I'm being sued.
What do you mean this was dismissed?
This was dismissed. I can to show you from Judge Coleman, it was dismissed. It said the court further orders Janae Lindsay is dismissed. This was dismissed 10/21/2021.
What's the case number in the upper right-hand corner?
The case number is 213-50846. This is somebody else suing me. I was originally sued by.
What are the last two digits? That should be two letters after that. After the numbers, there should be two letters.
Are you talking about the bar number?
No, I'm talking about the case number that you just gave me. To the right of that should be two letters.
It just say 213-50846 Jones Coleman.
Okay, that's a landlord-tenant case.
This is the same.
Well, look.
I'm not making my own rules. I'm listening. I'm not cutting you off.
The landlord-tenant case was about possession of the property. Who has the right to possession of the property? This is a claim that money is due as a result of your tenancy in that property. They're two separate claims. You understand?
I do understand, but the judge told me I can stay there, that I didn't have a move. It was the middle of COVID. Nobody was renting.
That's not what this claim is about, ma'am.
Okay.
Again, like I told you, that was a claim for possession of the property. And the judge said you could stay there. The judge did not say you could stay there rent-free.
The judge
this is a claim that rent and damages to the property were made, and that's what this is for. Two separate cases.
So can I ask you, when I went to court the first time, they didn't enter a judgment. They wasn't asking for rent. Because
I understand that. And again, in the landlord-tenant division, people as landlords can ask for two things. They can ask for possession only, or they can ask for possession and money.
They was only asking for possession.
That's the point I'm making.
Okay.
Since that was the only thing that was before the court, the question of whether you do or don't owe money as a result of tenancy has not been adjudicated. That's what's for me.
Okay.
April 4th at 10 o'clock. The written discovery is now open. Thank you both for coming in. Yes, ma'am. We're off the record.
Thank you, Judge.
Have a great day and let's be safe.
You as well.
Mr. Carter, good morning.
Your Honor, how are you?
Great. What brings you here?
I have,
XLNC?
no, sir. I have credit acceptance versus Natasha Hicks.
Credit acceptance versus Natasha Hicks?
Correct.
I have that on my list today. What is your case number?
22-200-457 GC.
22-200-457.
Correct.
Okay, you're not on my list. My clerk is looking it up right now, and she should be calling me shortly.
Sounds great. I think it was a control date. I think we put the settlement terms on the record and we were gonna send in settlement documents, but the defendant never sent them back to us, so.
Here's my my court clerk. Can you hang on?
Yes.
Mr. Barter?
Yes, sir.
Case was dismissed without prejudice, noting a conditional dismissal to follow. And the conditional dismissal apparently has not followed.
Correct, because a conditional dismissal has to be signed by a defendant. So if a defendant never signs it, never sends it back to plaintiff, then plaintiff, so the case just, so we'd have to file a motion to reopen the case because the defendant didn't send it back to us?
Yes. Did she get it? Because you typically offer terms better than your complaint. Why would she not sign it? She agreed to the terms on the record.
She said that she didn't receive it.
Okay.
So, in a voicemail, and we've been trying to call her back to get an email to send it to her.
Send a snail mail again. That's all you can do.
All right, perfect. And then if she's never to sign it or never contact us.
File a motion.
Okay.
Okay.
Perfect.
Have a great day.
Thank you. You too.
Bye-bye.
Morning, Judge.
Fox, good morning. What brings you here today?
Judge, I'm very early. I'm not scheduled until your 11 o'clock.
Oh, okay.
Ediac Pan versus Banyan.
Yep, I see you at the bottom. Okay, back to the waiting room.
Thank you, Judge.
Counsel?
Good morning, Your Honor.
This is 22-197-787. XLNC Investments LLC versus Ebony Fareed. Date and time for pretrial. Can I have your appearance?
Good morning, Your Honor. Randy Levasseur, P41712, appearing on behalf of the plaintiff.
Mr. Levasseur, this is our first pretrial. By a notice dated February 7, 2023, this matter set for pretrial today, March 7th at 10 o'clock. It's now after 10:30. Defendant has failed to appear. No good call of that failure having been shown. The defaulted defendant is hereby entered. We'll send that out to you today, sir.
Thank you, Your Honor. I believe the defendant has already been defaulted.
Oh, she filed an answer.
Prior to that, we filed a default with the court for failure to answer. I believe the court entered that, and then she filed an answer subsequent to that without having set that default aside.
Well, in any event, We'll default it again.
Thank you, Your Honor. We will file the appropriate motion for entry of judgment.
Thank you. Have a
Thank you.
great,
Have a great-
we're off the record. Okay.
Bolero inspired by a Spanish dance by that name. Leonard Slackton and St. Louis Symphony Orchestra was music that was intended to be danced to, but mainly known now as one of the most popular concert pieces for the concert hall. Maurice Ravel, the WRCJ-FM in Detroit, one of his signature works, and here's probably the best of the music attributed to the Baroque composer Tommaso Vitali. We're not exactly sure that he wrote this music, but he gets the credit for this chapeau in G minor. There's an arrangement for recorder and guitar, but in kind of Petri and Rice, kind of WRCJ-FM, the pilot factory plant in Portland has cannabis from car to that not probably WRCJ-FM. Stick with us. Our Ticket Tuesday is going to kick back up in just a couple minutes after the other symptoms of the WRCJ. Metro Detroit Winter Forecast message for that message. That's moved on out. We have technically it's in the low 40s. Today, 6 Celsius and afternoon southeast Michigan, southern Ontario, 90.9 FM Detroit.
Real. Morning.
Good morning, Your Honor. For some reason, my name is all messed up. I'll have to change that real quick.
This is Consumer Portfolio Services versus Tiffany Sewell. Case number 22-194-604. Your appearances.
Franco Barilli, attorney for the plaintiff, Consumer Portfolio Services.
Bar number.
P69468.
And what is your name, ma'am?
Tiffany Sewell.
Okay, this is our third pretrial on this file. Your written discovery has been open since January 10th. How are we doing on that?
Well, I was waiting on a response from Miss Alyssa. She said she was working to get me a response, and I was telling her, hey, I was trying to solve this before we went back to court. She said she still hadn't heard anything back. So she was like, I'm going to try to get you a response before 11, but I just checked my email again, and I haven't got anything back.
Counsel?
Yeah, Your Honor, those are settlement discussions. As far as discovery is, in my mind, it's closed. I've submitted all documentation to Ms. Sewell. I do not have any no requests that need to go out, and I have not received any discovery requests from Ms. Sewell.
Ma'am, are you going to do any written discovery?
I'm not sure exactly what that is. I thought I was supposed to be going back and forth with her to find an agreement.
Written discovery is your opportunity to learn about the claim.
You're muted. I can't hear you.
I'm not muted.
Hello?
Can you hear me, counsel?
I can hear you, Your Honor.
I can't hear anything you're saying.
Well, ma'am, I don't know what to tell you. Counsel can hear me now. My microphone is not muted. That's on your end.
Can you hear me?
Yes, I can hear you.
Okay, now I can hear you. Can you repeat that? I'm sorry.
I'm asking of you, do you intend to do any written discovery? Written discovery is your opportunity to learn about the claims and defenses of the other side. It includes such things as written questions to be answered under oath. They're called interrogatories, requests for admissions of facts, and demand for production of documents. Are you going to do any of that? Or are you prepared to go forward? I mean, you've had discovery open now for 2 months.
Yes, but I'm sorry. I thought that we were at a different point.
Okay, well, this is what I'm going to do. I'm going to give you guys a return date of April 4th at 11 o'clock. Your discovery will close April 1st. We'll be on Zoom like today, April 4th at 11 o'clock. We'll send out an order. Thank you both for coming in, and let's be safe out here.
Thank you.
Counsel, good morning.
Hi, Judge. How are you?
Good. How about yourself?
Not too bad.
What file do you have?
The last three are 695. It's credit acceptance and Bryson.
Okay. I don't seem to see that name. So back to the waiting room you go.
Sounds good.
All right. Let's see. Let's try this iPhone. Morning. Hello? No audio. Hello?
Good morning, Your Honor.
What is your name?
My name is Joelle Wright Terry on behalf of Memorials by Marshall Sassy, INC.
Okay. You are a small claim appeal. Small claims appeals are done de novo, but they're done off the record. So you will be at the end of the call because I have to do all the other cases that I have to do on the record. Then I have to go shut off the record and come back and do you. Okay?
Yes, sir.
Just to let you know, you are iPhone.
Yes, sir.
Okay, put on your patience.
Thank you, sir.
Hello? Hello?
Hello,
What is your name?
my name is John Kane.
Okay, so you're Motorola. Okay, Mr. Kane, I don't have your opponent as of yet. Put you back in the waiting room.
Okay, Your Honor, can I say?
Hello? Hello?
How you doing, Your Honor?
What is your name?
My name is Davon Burt. There are two other people that should be with me in the waiting room.
I'm sorry. Your name is what?
Davon Burt.
What case are you here on?
I have case number 231-40446.
Oh, okay. All right,
Yes,
I'll
but
put you back. I'm sorry. Go. What do you want to say, sir?
sorry. There's two other people that should be with me.
Well, we're not at that case yet, but I know who you are now.
Okay, thank you.
Hello?
Yes,
What is your name?
Nanaya Amuchi. And I use they, them pronouns.
Are you on this? And you and what is the case number you have, ma'am?
No, you don't need to give me any notorieties just by my name.
What case number do
Hello?
you have?
Yes.
What is your name?
The case. Nanaya Amuchi. And I use they, them pronouns.
What is your case number?
My case number is 231-40446.
Okay, I put you back in the waiting room. That's two of you. I have one more person apparently. So this is Chi and Devon B.
Hello? Hello, can you hear me? I cannot hear you. Your microphone is muted. Your microphone is muted.
Can you hear me now?
I can hear you now. How are you?
I'm good. What is your name?
My name is Edidiong Adiakme.
All right, I think I have two other people, Mr. Cox.
Yes, all three of us are in the picture. We are together. We are the plaintiffs.
Well, we have some problems with your pleadings, but let's get everybody in here and let's get started.
Okay, thank you.
This is Devon B is one. And then this person here.
Mhm. Exactly.
All right, I think I have two other people.
Hello?
Okay. I'm waiting for one more person to unmute.
Okay, that is Devon, Deb.
I'm here.
All right. This is file number 23-140-446. Oh, where's my file? Oh, excuse me. Oh, here we go. And could I have your name, ma'am?
My name?
Yes.
Okay, my
You are the main
government.
plaintiff.
Yes, my government name is Edidiong Adiakme, but I go by Didi.
Mr. Cox, your appearance.
Are you speaking to me?
No, I'm speaking to Mr. Cox.
Okay.
Mr. Cox. I guess he isn't here.
I saw him on video.
I saw him too, but he's not responding. So. Are you with us, Mr. Cox?
I am, Your Honor. Sorry about that. We're having some internet problems here.
All right. This is case 23-140-446. Could I have your appearance, please, again, Madam Plaintiff?
Are you talking to me or are you
Yes,
talking
because you
to?
are the named plaintiff.
Okay, it's three of us, but
No,
sure.
ma'am. You are the named plaintiff.
Okay,
You
that's
filed a
fine.
complaint in your name and all tenants. Tell us what your
That's not how I filed it, but I will read out my case number. My case number is 23140-446.
Okay.
Yes.
Appearance, Mr.
But
Cox.
in our motion, we did list 3 tenants.
Ma'am, the complaint controls here. I'm looking at your complaint and it describes you as the plaintiff and all tenants. So we
Okay.
no, I'm not going to argue with you. We have a pleading problem here, but we'll get it straightened out. Mr. Cox, your appearance.
Good morning, Your Honor. Aaron Cox, P69346, appearing on behalf of the defendant counter plaintiff.
All right. Now I have 2 other individuals. There's someone who's identified as Devon B. What is your name?
Good morning, Your Honor. My name is Davon Bird. My pronouns are she, her, theirs.
And what is your name? Looks like it.
My name is Nanaya Mbuchi, and I use they, them pronouns.
All right. Well, here's the first thing. Lawsuits have to be prosecuted in the name of the real party in interest. You will have to file a first.
We put our legal names on our form.
Excuse me, ma'am. You may not interrupt me. We're on Zoom, but this is a courtroom. And when I'm talking, you're not. Do you understand that basic rule of courtroom decorum?
No, I do. Thank you.
Good. You have an absolute constitutional right to represent yourselves. An absolute right to do that, or you can appear by counsel. If you elect to represent yourself, as is your constitutional right, you do not get your own set of court rules. You must follow the same rules of civil procedure, the same statutes, the same case law as Mr. Cox or any other lawyer. You will not be heard to say you don't know the rules if you elect to represent yourself. So the first thing I'm going to urge you as strongly as I can, and again, I want to remind you, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. Secondly, as a general rule of pleading, pleadings must be prosecuted in the name of the real party in interest. If you are a plaintiff in the case, then your name is not all tenants. Your name is whatever government name you are using. So you will have to file an amended complaint identifying by name all plaintiffs in the litigation. So, Madam Plaintiff, you are the person who brought the case. Tell me what your case is about.
Okay. We have filed a complaint in PDF format that we uploaded when we made the e-filing. We have copies of that in print as well that we can share in the Zoom. But everything I'm going to read out now is what we have submitted to your court, and we have proof of service, we have receipt numbers, and any other additional information you need, including screen sharing the PDF that shows our government names. So I'm going to
stop right here.
Out my I'm going to read out my amended complaint.
I do not need you to read the complaint. I'm asking you what your complaint is about.
It's about retaliation. It's about retaliation. We have a retaliation case against Banyan Property.
Okay. And one of the things that I read in your case was that apparently the lease had expired and then you folks became tenants.
That was a lie.
That was a lie. Okay. All right. Well, look, apparently we're not going to get anything done here today. So what I'm going to do.
We are trying to consolidate our case today.
No, ma'am. You have a landlord-tenant case that is pending before another judge. Has that case been resolved or not?
The case is scheduled for April, and we don't want to resolve the case without consolidation. So either we consolidate the court, the stuff here or there, because if we don't, that will be using our resources unwisely. The plaintiff or the defendant has already filed in that court to close that case because they are accusing us of giving identical complaints. But the reason we're giving identical complaints is because this issue stems from the same issue, retaliation. And so we want to consolidate this case either in this court or that court so that we are not accused of giving identical complaints in two courts. We just consolidate it, and it helps with the economy of the court. And we're trying to do that here because we are having a retaliation case in both courts.
What's going on in the landlord-tenant case?
We are fighting a retaliation case against Banyan. They are retaliating against us and trying to evict us based on retaliation for us exercising our right to negotiate our lease.
Let me hear from Mr. Cox.
Yes, Your Honor. I mean, she's accurate.
Landlord-tenant case.
We have an adjourned hearing scheduled for April 11th, 2023 at 9:30 a.m. before Judge Jacquet.
Okay.
At that time, the court, I anticipate, is going to entertain our motion to dismiss counter complaints that they filed in that case that are identical to those complaints filed here, as well as our motion for entry of a judgment under MCR 4.201J2, because there's no triable issue with respect to the possessory issue. If the court does in fact entertain those motions and grant the relief I anticipate they will, then their motion to consolidate will be mooted. They will proceed before you on their monetary claims, leaving the possessory issue before Judge Jacquet. Even if the judge doesn't grant that relief, I do ultimately think that's the outcome, because the landlord-tenant possessory action is a separate, distinct proceeding from the monetary disputes between the parties that's before this court.
Okay, let me do this. Let me make a stab at an explanation. In the landlord-tenant matter, there are basically two issues. The first issue, who is entitled to possession of the property? That issue is exclusively within the purview of the landlord-tenant division. It will not be heard in general civil. In the landlord-tenant division, there may or there may not be a claim for money damages. If the only thing that is resolved in the landlord-tenant division is the possession issue, then the question of whether there may or may not be monetary damages can continue in the general civil division. If a decision is made on both possessory issue and monetary issue in the landlord-tenant division, that would operate as res judicata, that is a decision on the same issues with the same parties in this case. In any event, in this case, the pleadings in this case, this is not small claims. This is general civil. And in the general civil claim, we have a problem right now with the named parties. The rules in the general civil division require that a plaintiff or a claim be prosecuted in the name of the real party in interest. So the plaintiff will have to file a first amended complaint if you intend to continue with more than one plaintiff.
We have filed an amended complaint with our government names on the complaint. We can upload it now to you in this chat.
Do you have that, Mr. Cox?
I do, Your Honor. They did. I can't tell you whether or not the court has processed the filing, but I received
the court has,
a
because
copy.
we have the proof of service.
I did receive a copy of an amended complaint.
And
I have it
in the
dated.
court transcripts.
I have it dated in my file, Your Honor, as February 11th, 2023.
All right, then this is what I'm going to do. Because I'm looking at defendants.
We also have a motion to consolidate that we shared with Judge Jacks. Judge Jacks at that court told us to come to this court and argue for consolidation. And that is why he gave us an April court date. We met him on February 14th, and he said he will not make a decision on February 14th till we've come here and argued for our motion to consolidate. We also gave him the motion to consolidate, and he said his court cannot hear it. And so while we were waiting here, Aaron Cox sent us a reprimand telling us that we were filing identical claims. And we said, Aaron Cox, the Judge Jacks already told us to come here and argue to consolidate so that we don't have to file identical claims. But now Aaron Cox is telling Judge Jacks to close our case because we have identical claims. And we are telling them we don't have identical case if we have one case. So we're trying to consolidate it. We cannot go back to Judge Jacks because he told us to come here on February 14th. He said, come here on February 14th and argue to consolidate here. And if you don't get it, then come in April 14th to argue there. But the two cases stem from the same issue of retaliation. There is no difference.
All right. This is the
retaliation to the defendant, or
this is my decision. I am going to deny your motion to consolidate.
Why?
Excuse me. If you would listen, perhaps you could hear my explanation. I would appreciate the opportunity to speak without interruption.
Sorry.
I thought we had this conversation before.
I'm sorry.
I don't want to repeat myself.
You won't.
What I'm going to do is I'm going to deny the motion to consolidate insofar as it relates to issues of possession of the property. You folks will decide with Judge Jacques what the decision is in regard to the possession of the property, who's entitled to be in the property. The monetary claims will proceed in my court under your amended complaint. You will have to file. I see your first amended complaint apparently identifies 3 individual named plaintiffs. That's fine. So what we're going to do is I'm going to enter an order denying your motion to consolidate insofar as it relates to possession of the property on Atkinson.
That was not our argument in that consolidation case, Judge. Our argument was retaliation.
Ma'am.
So you're denying our
listen.
consolidation because you're saying we argued for possession. We did not argue for possession of the property.
Ma'am,
We're arguing for retaliation.
you're not listening. And let me make something else clear. If you disagree with my decision, ma'am, you have an absolute right to appeal it. An absolute right to appeal it.
That will waste more
excuse me.
judicial resources.
Excuse me, I am not going to argue with you. This is what I'm going to do. I will enter an order granting the motion to denying the motion to consolidate insofar as it relates to the possession question of the property. I will open your written discovery. I will give you a return date, and that return date will be April 4th at 11 o'clock. Does that work for everybody?
Your Honor, since we're all named, can I speak?
Yes, ma'am.
So I hear you on this, but I wanted to state for the record that when we went to Judge Sean Jack, he said that retaliation precludes any claim for possessory. That is it's a defense to the eviction. And so we need to determine retaliation before we can even get to possessory.
Mr. Cox.
Your Honor, while retaliation is an available affirmative defense in a termination action, it is not an absolute defense, and it's one that must be proven. I was not present at the prior hearing, but I certainly don't think that they've properly pled or proven that defense. And I think that the outcome before Judge Jacquet on the possessory issue is inevitable.
Well, whatever the outcome is, it's in between Judge Jacquet and the folks who are litigating the case. That is not before me. I don't know how much more clearly I can say that. And so I'm going to stop repeating myself. I'm going to tell you what I'm going to do.
Thank you.
You disagree with my order, you have an absolute right to appeal. That appeal must be perfected in the Wayne County Circuit Court under the Michigan court rules. I will issue 2 orders today. I will issue an order denying the motion to consolidate insofar as it relates to the question of who is entitled to possession of the property. I will enter an order for April 4th at 11 o'clock, which will be our next pretrial. And in the interim, I will open your written discovery. And so I would urge you, if you want to represent yourselves, you have an absolute constitutional right to do that. What you do not have, and I want to make this perfectly clear, you do not have a right to your own set of rules, civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that are binding on Mr. Cox are binding on you. And you will not be heard to say you don't know the rules. So I would urge you, but I'm not requiring, I would urge you to get counsel. But again, that is your decision. So 2 orders coming from me. An order for April 4th at 11 o'clock will be our next Zoom pretrial. Your written discovery is now open. Second order will be an order denying the motion to consolidate insofar as it relates to the claim, the question of who is entitled to possession of the property. Is there anything else we can accomplish today?
Yes, Judge, please. And I'm saying this in the most kind way possible. I don't want to go against you because I know like you are saying what you need to say. So I appreciate you coming in here today to work with me. April 4th is actually not a good day for me because of my surgery. So I was wondering if we could have a sooner day in March, preferably as soon as possible. I'm trying to have this behind me before my surgery.
Well, here's the problem. The written discovery operates on a 28-day cycle. So if I have a hearing before 28 days and written discovery is issued after today, it will not be due at the time we are next together.
Judge, if we can get a sooner date before April 4th, 28 days from now, I think we'll have some time before April 4th. We'll get everything we need to. I just I cannot have our next hearing be before my surgery, if that's okay.
When is that
I'm-
scheduled?
For HIPAA reasons, I can't share too much private information.
I don't
It will
want to
be
know
in
what, I want to
April.
know when.
Yes, April.
No.
I will go
HIPAA,
through
you
my
have a
records.
date.
They told me the first week of April.
Okay, then we'll do it.
So I just need something before then.
No. Again. Today is what day? March 7th. Is that right? What's
Yes,
7
Judge.
28?
Correct.
Be 35. So if I do it in March, any discovery would not be due yet. So let's do it later.
Or we can keep to April 4th. That's fine. April 4th is fine.
Well, if one of you has a problem with it, I don't want to be forcing people.
We can
We'll
keep
just have
April,
a later date, that's all.
we can keep April 4th. That's fine. We can adjust the appointments because we don't want to delay it further. So April 4th is fine with us. And then I had a second question.
Mr. Cox, does April 4th work for you?
It does, Your Honor, yes.
Okay. April 4th at 11 o'clock, written discovery is now open.
And then Your Honor, I had a second question.
Give me just a second.
Okay, thank you.
What was that question, please?
Since the amended complaint, there's been a couple other documents filed. One being motion to a summary disposition by Aaron Cox, and then we had a defendant's response to the plaintiff's response to motion for consolidate. We're just checking if your office received that. We have the proof of service and whether or not that's relevant for
At
today.
this time, it is not relevant.
Okay, thank you.
Okay, then we'll see you April 4th at 11 o'clock, and we'll be on Zoom. You'll get 2 orders from me. You'll get the scheduling order and the order in regard to the motion to consolidate. Thank you all for coming in. We're off the record.
Thank you, Your Honor. Have a great day, Judge.
You too. Be safe now. All right, this is Mr. Kirschenheiter. 22-184-695 Credit Acceptance Corporation versus Monique Bryson. By a notice dated February 7th. We're here to check out whether or not the consent judgment has been entered. Has that been done?
Your Honor, we did not get the paperwork back from defendant.
Well, I'll give you another date, but I can't hold this on. If you don't have, you need to move forward one way or the other.
Yeah, I agree, Your Honor. I agree with you, so.
All right, I'll give you one more date.
Thanks, Judge.
April 4th at 11 o'clock.
Thanks, Judge.
I'll send it out again.
Have a wonderful day.
You too. Mr. Beers.
Good morning.
This is 22-189-944 UHG1 LLC versus Robert Wilson. This is our first pretrial on this case, which had been reinstated by a notice dated February 10th, 2023. The matter set for pretrial today at 11 o'clock. It's now after 11:30. Could I have your appearance, please?
Good morning, Your Honor. Jeffrey Beers, P 41693 on behalf of plaintiff UHG.
Mr. Beers, the defendant has failed to appear. No good cause for that failure having been shown. The default with the defendant is hereby entered. We'll send it on out to you today. Thank you for your patience.
Thank you, Your Honor. Have a good day.
Great day. What is your name, sir?
John Kane, sir, Your Honor. Susan Michael.
Yeah, you're all set. I'm waiting for the other side to come in.
Yes, Your Honor.
All right. We are on the record calling file 22-193860, John Kane versus Elizabeth Lofts. Could I have your appearances, please?
This is John Kane.
Good morning, Your Honor. Peggy Madden, P 39308 on behalf of Elizabeth Street Lofts.
Okay. First question is there a judgment in the landlord-tenant case?
There is, Your Honor.
Okay. Nobody bothered to give it to me.
Well, here's the problem. It's very difficult to get the landlord-tenant judgments returned to council. I have stacks that have been entered and indicate on the ROA that they've been mailed, and I've received 2 out of approximately 40. But if you...
When was the judgment entered?
Oh, I believe I'd have to look that up. And while I'm looking for that, if I can indicate for the record that when you review the ROA, you can see that Mr. Kane has filed several motions to try to set aside the judgment, to give him more time and so forth and so on that have been denied by Judge Sherman. Mr. Kane was a resident of that building when my client bought the building. And despite his assertions and his motions that he's but never missed rent, he hasn't paid rent himself since 2019.
Do you have any idea, Ms. Madden, when you should get that? Because I'm hard pressed to make a ruling in the absence of knowing what the court, you argue in essence in your motion to dismiss res judicata, and yet I don't have a judgment.
Right. And I understand the court's frustration. I'm going down there this afternoon and I can try to physically get a copy, but to be frank with you, Judge, I just can't understand why I'm not getting any judgments that are shown as entered. It's very difficult for me to even get writs because sometimes the judges change the dates that have been placed on the record and you have to wait for the physical judgment. So it's really, frankly, been a bit of a nightmare.
Mr. Kane, you didn't file an answer to the motion to dismiss. Are you just opposing that motion?
No, sir. What's going on is,
No, all I need to know is whether you oppose her motion to dismiss. If you don't, I'll dismiss the case and that's the end of it.
now explain that to me again, Your Honor.
She has filed a motion to dismiss your case. You did not file a written answer to the motion. I'm asking you if you oppose the motion.
Yes, I oppose the motion, Your
Sir,
Honor,
you
because
didn't file an answer.
I went to seek counsel, and counsel just called me today and asked me, Counsel Brenda Richards from
Don't
Lakeshore.
tell me, stop. Don't
Yes.
tell me anything about any conversation you had with a lawyer. Is that lawyer going to file an appearance in this case or not?
Yes, sir.
Yes or no question.
Yes, sir. They told me to ask you for adjournment for 30 days and they're going to take the case.
All right, then this is what I'm going to do. I'm going to adjourn the motion to dismiss to April 4th at 11 o'clock. There will be no further adjournments.
Yes, sir.
And Your Honor, if I may indicate something else for the record.
Please.
And I'm just checking on that April 4th date. When I looked at the ROA this morning, I saw that Mr. Kane, who has a habit of filing pleadings without serving me, filed a motion on this case, which I have not received.
Did you file a motion on this case, Mr. Kane?
Yes, I did, Your Honor.
When did you file that motion?
Last week.
Why did you not serve the other side?
I went to Lakeshore Legal Aid. And
why did you not serve the other side?
I didn't know. I was ignorant, Your Honor.
Sir, well, let me make something very clear to you. If you elect to represent yourself, as is your constitutional right, you have an absolute right to do that. What you do not have is the right to your own set of court rules.
Yes, sir.
Your own set of statutes and your own case law.
Yes, Your Honor.
You are going to represent yourself, as is your constitutional right. The same rules that bind Ms. Madden bind you. And you will not be heard, at least in my courtroom, to say, oh, Judge, I didn't know the rules. So it's going to be one of two things. Either you represent yourself or you don't. If you have counsel, then have counsel file the appearance. The appearance is a document by which the attorney says he or she will represent you. Until they file the appearance, they are not in the case. If, on the other hand, there is no attorney, and right now there is no attorney for you because no one has filed, whatever motion you file, you must serve Ms. Madden. You must file a copy, proof of service, indicating that she has been served with that. Now, let me make this clear to you. You have a right to use the court system. You do not have a right to abuse it.
Yes, Your Honor.
You will not be heard going forward to say, I didn't know I had to serve the other side.
Yes, sir, Your Honor.
You are the plaintiff. We are here for one reason, and that is because you filed a lawsuit. If it's not important enough to you to follow the court rules, it will not be continued in my court. Now, you may take it somewhere else, but it will not continue here.
Yes, sir, Your Honor.
So before we are together next on April 4, you will serve Ms. Madden with a copy of the motion that you filed. You will serve the court with a copy of the motion and file proof of service that Ms. Madden has been given a copy of whatever motion was that you filed. Does that April 4th, 11 o'clock work for everybody?
That should be fine for me, Your Honor.
Okay. Now, if this lawyer, whoever it is going to represent you, have them file the appearance. Until that lawyer files the appearance, they are not in the case. Do you understand that?
Yes, sir, Your Honor, I do.
April the 4th.
April 4th, 11 o'clock.
Right.
We're going to hear Ms. Madden's motion. Ms. Madden's going to try to get me a copy of the judgment in landlord tenant. And Mr. Kane is going to serve Ms. Madden and the court with whatever motion he recently filed. All right, that's it.
Thank you, Your Honor.
Thank you, Your Honor.
11 o'clock. We're off the record. All right, you're here for Marsh and Sassy Monument?
Yes, sir, Your Honor.
Okay, I'm getting I don't know where the plaintiff went, but in any event, as I told you, because this is a small claims appeal, small claims matters are done off the record. I'm gonna have to leave my chambers, which is where I am now, and go into the courtroom, shut off the recording device, and I'll be right back here, okay?
Yes, sir.
Here she is, right here. Maybe. See if we can get her in here. What is your name?
Tria Brown.
All right. I was explaining, so let me do this again. You are here on a small claims appeal. All small claims matters are done off the record. I am going to have to leave my chambers, which is where I am now, go into my courtroom to shut down the recording device, and then I'll be back so we can have your pretrial, okay?
Okay, thank you.
All right, so I'll be back in just a second. Take me a couple minutes to get over there and shut things down.